I'm Jeb Butler of the Butler Law Firm, and today we'll talk about defendants' attempts to delay cases when there is a concurrent criminal proceeding. In other videos, we've talked about the difference between civil cases, which we handle, and criminal cases, which are brought by a government to try to put someone in jail. In some cases, both types of cases can run concurrently, that is, at the same time. An example of that could be a sexual abuse case in which we're pursuing a civil case arising out of the abuse, but then the state or federal government is trying to prosecute the assailant or the attacker and put them in jail. A civil case like ours is about money, criminal case about putting somebody in jail, but they can usually run at the same time. There are some defendants, though, who attempt to slow down the litigation process, and they'll try to use a concurrent criminal proceeding as an excuse to do that. So we'll be going in our civil case, it could be a sex abuse case, it could be a trucking case against a driver who's being prosecuted. And sometimes the defense will file a motion asking the court to stay, which means to pause our entire case while the criminal case goes on. Now this could be really bad. The litigation process is slow enough as it is, and if we have to wait on a criminal case to conclude, that could take years. And we would be paused and doing nothing for all that time. So obviously when the defendants file those motions, when they seek to pause our cases, we object. And typically, we're able to win those cases. I'll look at one of our orders, and one order that comes from a friend of mine. So here is an order in a federal court. This is a sexual abuse case that our firm is handling. And in it, we were bringing our case, and then there's a criminal case going at the same time. And what the defense wanted to do was they asked the court to stay all discovery under the federal rules until final resolution of a related criminal case. Now, we oppose that because all that really is an excuse to delay things, which defendants often want to do. We pointed out that there was no reason we couldn't go on at the same time, that the criminal defendant could invoke his Fifth Amendment right in our case, and our client would get the benefit of an adverse inference, which is kind of technical stuff, but basically our point is there is no reason to stop. We can keep going. And the court agreed with us. If we scroll, it's quite long. The court did a great job describing all the reasoning. But at the end, here's the important part. The court denied the defendant's motion to stay all discovery. So we get to keep going. That's good because for this client, the case will go just a little bit faster. And it's also good because this is a nice written order with a heck of a lot of good explanation as to why the court is ruling with us. And so we can use that in future cases. We can say, if a future defendant tries that, we can say, well, look, here's what another judge did when they made the same arguments. That court denied the motion, and Your Honor, you should too. So that can be persuasive. And it's not just us. I wanted to show off another order. This comes from my friend Matt Stoddard, who's another personal injury lawyer in Atlanta, and with whom we work from time to time. His case involved it was a premises liability case, and the defendants in that case did the same thing. They filed a motion asking an order to stay or pause litigation pending resolution of the criminal charges. And he did a good job. He opposed it the same way that we would, and he won it. Ordered the motion to stay is denied. So that's good for all the same reasons. He can use that in his future cases. I can use that in my case. He can use our order in his cases. So it's a good thing. It helps us to keep our clients' cases moving as fast as we can. The litigation process takes a long time as it is, and there is no reason to make it take longer.